Madam President, each of us has taken an oath to support and defend the Constitution of the United States. President George Washington called the Constitution the guide that he would never abandon. The Constitution declares itself to be the supreme law of the land, and more than 90% of Americans say that it is very important to them. Unfortunately, basic knowledge about the Constitution is dangerously inadequate. I say this is dangerous because, as James Madison put it, only a well-instructed people can be permanently a free people. The current debate over when to fill the Supreme Court vacancy left by Justice Antonin Scalia's death only magnifies my concern. Ignorance of not only how the Constitution applies to this question, but even what the Constitution says apparently extends far and wide. Here's the text of the Constitution regarding the appointment of judges and other public officials. The President shall have power to nominate and with the advice and consent of the Senate, shall appoint judges of the Supreme Court and all other officers of the United States whose appointments are not herein otherwise provided for, and which shall be established by law, unquote. This is what the Constitution actually says right here for everyone to read. The Constitution gives power to nominate to the President and gives the power of advice and consent to the Senate. It says nothing about how the President and the Senate should exercise their separate powers. In fact, the judicial confirmation process has been conducted in different ways at different times and under different circumstances. Our job is to determine how, under current circumstances, best to exercise our power of advice and consent. Several factors convince me that the best way to do so is to defer the confirmation process for filling this vacancy until the next president takes office. First, this is only the third Supreme Court vacancy in nearly a century to occur after the American people had already started voting for the next president. In the previous two instances, 1956 and 1968, the Senate did not confirm a nominee until the year after the presidential election. Second, the only time the Senate has ever confirmed a nominee to fill a Supreme Court vacancy created after presidential election voting had begun was 1916. That vacancy arose only because Justice Charles Evans Hughes resigned to run against President Woodrow Wilson, a completely different situation than we have before us today. Third, the judicial confirmation process has become increasingly combative, especially for the Supreme Court. Attempting to conduct this process in the middle of an already divisive presidential election campaign would be especially difficult. Fourth, President Obama's judicial appointees and Justice Scalia represent two radically different kinds of judge. This offers the American people a unique opportunity to express, through the election, their view of the direction that the judiciary should take by electing the president who will make judicial appointments in the next 4 years. In June 1992, then Judiciary Committee Chairman Joseph Biden, a friend of mine, made the very recommendation that we are following today, based on some of the very same factors that I just mentioned. In particular, he noted that the appointment process would take place in divided government during a presidential election process that was already underway. He could have been describing 2016 instead of 1992. Madam President, the Constitution does not mandate a particular process to address this Supreme Court vacancy. We have to look all the way back to the 19th century to find a year in which the Senate confirmed a Supreme Court nominee of the other party in a presidential election year. That, of course, was long before the courts became as powerful and the confirmation process as confrontational as they are today. Democrats can read the Constitution and understand the historical and political facts as well as anyone else. Why then are they making such bizarre claims? Last week, for example, the minority whip said that the Constitution requires, quote, a fair hearing and a timely vote, unquote. He claimed that this conclusion comes from the plain text of the Constitution. Well, I had the plain text up here, and it clearly says nothing whatsoever about hearings or votes. As I said, the Constitution gives the power to nominate to the President and the power of advice and consent to the Senate, and leaves to each the judgment about how to exercise their respective powers. Last week, the senator from California, Senator Boxer, said that deferring the confirmation process would be an abomination. She said that the Constitution's standard for the Senate's advice and consent role does not change with the party of the president making nominations. And yet she voted 25 times to filibuster Republican judicial nominees, including to the Supreme Court. She voted not simply to defer the confirmation process, as we are doing today, but to prevent a confirmation vote from ever taking place. If the confirmation process should not change with the president's party, then she should have no problem with the decision we have made, since it is less drastic than the blockade she promoted just a few years ago. Also last week, an email solicitation signed by one of my Democratic colleagues asking for petition signatures claimed that the Senate has a, quote, fundamental duty to confirm nominees to the Supreme Court, unquote. I would like to think that this is simply an egregious typographical error, because it goes beyond even the false claim that the Constitution requires hearings and a vote. If the Senate has no choice but to confirm a president's nominees, what is the point of giving the Senate a role in the process at all? I will say it again in the hope of clearing up what should not have been confused in the first place. The Constitution gives to the president the power to nominate, and to the Senate the power of advice and consent. These are separate and independent powers, and the Constitution does not mandate any particular way for the president and the Senate to fulfill their responsibilities. Because this fact is evident on the face of the Constitution, I cannot understand my colleagues who say that the president has a 4-year term. That observation has nothing at all to do with anything before the Senate. The Senate is not doing a single thing and cannot do a single thing to interfere with the president's power to nominate. He can exercise that power in any way he chooses, including sending nominees to the Senate up to his very last day in office. He can do that. Nobody disputes that I know of. They might dispute how wise it would be to do it right up to the very last day in office. But nobody really disputes that he can exercise that power in any way he chooses, including sending nominees to the Senate up to his very last day in office. What the president cannot do is dictate to the Senate how we exercise our separate power of advice and consent regarding those nominees. Liberal allies of Senate Democrats are similarly confused. I received a letter signed by liberal groups, for example, claiming that the Constitution requires, quote, timely hearings and votes, unquote. It almost sounds like Democratic senators and left-wing groups are sharing talking points. Almost. Let's look once more at the language of Article 2. Now just refer to the chart. Tell me, where is the language about hearings and votes? I understand that Senate Democrats and their leftist allies want a timely hearing and confirmation vote this year to replace Justice Scalia. But wanting a particular confirmation process and saying the Constitution requires that process are two very different things. Some of the groups signing that letter, in particular, I noticed the Leadership Conference, the Alliance for Justice, and People for the American Way actively urged senators to filibuster the Supreme Court nomination of Samuel Alito. They opposed, in 2006, the very confirmation vote that today, just 10 years later, they say the Constitution requires. Democrats and their liberal allies must be reading the same made-up, shape-shifting Constitution that their favorite activist judges use. Because the real Constitution says no such thing. Democrats' arguments contradict not only the plain words of the Constitution, but also their own words and actions in considering nominees of a Republican president. As to hearings, then-Chairman Pat Leahy denied a hearing to nearly 60 judicial nominees in less than 4 years while George W. Bush was president. As to confirmation votes, the minority leader said in May 2005 that claiming the Constitution requires a confirmation vote would be, in his words, rewriting the Constitution and reinventing reality. Now that was the minority leader, the current minority leader at this time. Here's what he said then. Now let me just refer to the chart. The duties of the United States Senate are set forth in the Constitution of the United States. Nowhere in that document does it say that the Senate has a duty to give presidential nominees a vote. It says that appointments shall be made with the advice and consent of the Senate. That's very different than saying that every nominee receives a vote. Now that was the minority leader who was then the majority leader. Well, think about that. The duties, quote, the duties of the United States Senate are set forth in the Constitution of the United States. Nowhere in that document does it say that the Senate has a duty to give presidential nominees a vote. It says that appointments shall be made with the advice and consent of the Senate. Now that's very different than saying that every nominee receives a vote, unquote. I mentioned one Democratic senator who voted 25 times to prevent confirmation votes on judicial nominees. So did the minority leader, the majority whip, and Senators Leahy and Senator Schumer as well. In fact, Vice President Biden himself, when he served in this body, voted 29 times to filibuster Republican judicial nominees. And while President Obama today says that the Constitution requires us to vote on a Supreme Court nominee, as a senator, he too voted to prevent any confirmation vote for Supreme Court nominee Samuel Alito. In other words, these Senate Democrats voted over and over to deny the very confirmation vote that today they say the Constitution itself requires. They cannot have it both ways. Do we have multiple constitutions? One to use for a president of your own party, another for a president of the other party. Democrats today have no credibility whatsoever to dictate how the confirmation process should work for filling this Supreme Court vacancy. Madam Presidency, the Constitution leaves to the President how to exercise his power to nominate, and to the Senate how to exercise its power of advice and consent. Recent claims to the contrary are inconsistent with the plain text of the Constitution and with past words and actions of the very senators and grassroots activists making those claims today. The question is when, not whether, to fill the vacancy left by the untimely death of Justice Scalia. The best answer is to defer the confirmation process until after the next president takes office. Far from ignoring or shirking our responsibility, that conclusion tackles our responsibility head-on for the good of the judiciary, the Senate, and the country. Madam President, I suggest the absence of a quorum.